Your Lordship's permission. Warm welcome to all on behalf of BCMG and Virol for the book release ceremony of Gender Justice, Human Rights and P.N.D.T Act 1994, Critical Appraisal of Statutory and Judicial Perspective, written by Dr. UDAY Prakash Warunjikar. As the name suggests, the book is in respect of P.N.D.T Act and its critical appraisal. This act is not usual act. This act is the outcome of a moment. The moment which was started somewhere in 70s and 80s. In 70s, 80s, there was a research done by Ford Foundation in India, why the population of India is growing so fast. The Ford Foundation suggested that there is a requirement of a technology, introduction of a technology in India. That is why the sonography machines, those were introduced, the first machine was installed in AIIMS, Delhi. But then technology, whenever technology comes, the disadvantage of the technology that comes along. Technology is not dangerous. The human interference in the technology, that is dangerous. And the misuse of it, then this moment started rolling up. When the doctors started it, the private doctors started use of it, at that relevant time, the front page publications were made in the newspaper for the availability of this particular technology. And by using that technology, the gender discrimination started very fast in India. Now, as far as the misuse is concerned, there are three main reasons. One is the act. That is why there is critical appraisal of this particular act. Second, the technology. So, to curb this, there is a need of research in this particular area. Now, as far as research in our field is concerned, more often in legal field, the research is done by scholars. The scholars who are mainly into academics. But the research, there are very few examples where research is done by the person who is practicing in court on day-to-day basis. Mr. Warunjikar is practicing before Bombay High Court for more than 28 years. He has gained special knowledge as far as this particular subject is concerned. Using the same knowledge and his practical experience, he decided to go for research in this particular subject. And then, after this research, he has written this thesis, and based on this, now we are here to publish the same. In India, we have problem as far as gender justice, gender inequality is concerned. Everyone wants, Mala mulga paije. I want moksha. Mulga fakta mala moksha dil. So, for this purpose, we need to have a proper guidance. Now, that guidance is not only to the members who are into legal field, but also to the doctors, to the members of the society. And that's the reason now this book will help all of us. As far as V-Role is concerned, I would like to invite Advocate Akshay Deshmukh to introduce V-Role.
Good evening, everyone. With the permission of My Lord Justice Bhushan Gavai, My Lord Justice Abhay Oak, and dignitaries on the dais and off the dais, I would like to introduce what is the Warunjikar Institute of Rule of Law. Everyone is asking what is exactly the V-Role is. The basic importance to form this institution is to reach to the poor person or the person who cannot come to the court and to give affordable litigation to that person. Because of that reason, this V-Role is formed. To minimize the gap between theory and the practice, positive steps were required. When Dr. Warunjikar given lectures to judges, to public prosecutors, then it was found that it is required that the practical and there is gap between the practical and theory which has been taught us in school or in colleges. And because of that reason, we have formed this V-Role, that is Warunjikar Institute of Rule of Law. In future, we would like to file PILs, and we will conduct courses in this field of law. Also, we are conducting the legal research, and legal research, conducting the legal research is our main activity. We are also in the process of launching 2 books on the act, that is persons with the right of persons with disability act 2016 and the transplantation of human organs act 1994. We are inviting all the dignitaries and the persons who are present today to solicit and to come forward to join this activity. Thank you.
Today with us, we have special guest, Honorable Justice B.R. Gavai, Judge, Honorable Supreme Court of India. For us, there is no need of formal introduction of His Lordship, Mr. Justice Gavai. Justice Gavai is son of soil, is a mentor for BCMG. He's a backbone for judicial system. As far as Justice Gavai is concerned, His Lordship started his practice at the age of 25 at Nagpur. He has served both as government pleader as well as public prosecutor. Had a great practice, but when the call came, he opted to go for judiciary. And His Lordship served as judge of Bombay High Court for 16 years. And thereafter, after serving for 16 years, His Lordship was elevated to become judge of the Honourable Supreme Court. His Lordship is known for his quick decisions, practical approach, and keeping the court atmosphere live and energetic all the time. I request Mr. Warunjikar and Mr. Ajay Joshi to felicitate His Lordship Justice Gavai.
Thank you so much. First of all, good evening to all my friends and colleagues. I'm glad and I'm privileged and I feel honored to introduce His Lordship's Honorable Justice Abhay Oak. Justice Oak started his career as a lawyer in Bombay High Court and got elevated as a judge of Bombay High Court in the year 2003. Since then, as a judge, he put his impressions on all of us. There are so many remarkable judgments. There are so many legislations, so many laws, wherein Honorable Justice Gavai has framed various schemes to implement legislations with its letter and spirits. Honorable Justice Oak got elevated as a Chief Justice of Karnataka High Court in the year 2019, and recently he elevated as a Judge of Honorable Supreme Court of India. I most welcome Honorable Justice Abhay Oak for today's occasion, and I request to come forward Dr. Warunjikar along with Mr. Rahul Kadam to welcome and felicitate Honorable Justice Abhay Oak. Thank you so much. I know we are running a little out of time, and I'll try to make it as fast and as concise as possible. Let me introduce and welcome Honorable Justice R.C. Chavan, retired judge of Honorable Bombay High Court and presently Vice Chairman of E-Committee of Supreme Court of India. Please welcome. Yes, I request Dr. Warunjikar and Mr. Tushar Kale to welcome and felicitate Honorable Justice R.C. Chavan.
Today with us, we also have Mr. Manan Kumar Mishra, Senior Advocate and Chairman of BCI. I request Dr. Warunjikar and Mr. Devalanja to felicitate Mr. Mishra.
Now we welcome and felicitate Advocate Prashant Kumar. I request Dr. Warunjikar and Mr. Mayur Parab kindly felicitate and welcome Advocate Prashant Kumar, President of Bar Association of India.
Thank you. Today we also have Senior Advocate Sham Diwan, President-elect Law Asia and Vice President Bar Association of India. I request Mrs. Warunjikar and Mr. Siddesh Pilankar to felicitate Mr. Diwan.
Thank you so much. Now I request to kindly welcome and felicitate Advocate Jain Jayabhave, Member Bar Council of India.
I request Dr. Warunjikar and Advocate Akshay Deshmukh to felicitate Advocate Vasantrao Salunke, Chairman, Bar Council of Maharashtra and Goa. We also have Advocate Rajendra Umap, Vice Chairman, Bar Council of Maharashtra and Goa. I request Dr. Warunjikar and Advocate Vijay Dige to felicitate.
Thank you so much. Now I request Mrs. Warunjikar and Ms. Neha Deshpande to welcome Dr. Dilip Uke, Vice Chancellor, Mumbai National Law University, Mumbai. Mr. Warunjikar completed his PhD and his thesis under the guidance of Dr. Dilip Uke. Thank you so much. Now I request Ms. Gargi Varunjikar and Mr. Nitesh Gupta to kindly welcome Honorable Justice, Retired Justice A. Surya Narayan Naidu, former Judge, Bombay High Court. Kindly welcome and felicitate former Judge of the Bombay High Court. Thank you. Now I request Mr. Vyomesh Varunjikar and Mr. Shantanu Adkar to kindly welcome Advocate Shekhar Nafde, Senior Advocate, Supreme Court of India. I request Mrs. Varunjikar and Mrunmai Kambate to kindly welcome and felicitate Mr. Vinay Prabhakar Navre, Senior Advocate, Supreme Court of India. Thank you so much. Now I request Mr. Vyomesh Varunjikar and Siddesh Piyankar to kindly welcome Advocate Makarand Adkar, Advocate, Supreme Court of India. Thank you so much. Now, I request Ms. Gargi Varunjikar and Mr. Janish Jain to kindly welcome Advocate Varsha Deshpande from NGO Lake Ladki Abhiyan. Thank you so much. Now, I request Mrs. Varunjikar and Mr. Aditya Kharkar to kindly welcome Advocate Ved Prakash Sharma, Member, Bar Council of India. Thank you. Now I request Mrs. Gargi Varunjikar and Mr. Aditya Thorat to kindly welcome Advocate Apurva Sharma, Chairman, Executive Committee, Bar Council of India. Mr. Apurva Sharma. Thank you so much. Now I request Mr. Vyomesh Varunjikar and Mr. Janish Jain to welcome Advocate Nachiketa Joshi, General Secretary, Akhil Bharati Adhikta Parishad, Supreme Court Unit. Advocate Nachiketa Joshi by Vyomesh Varunjikar and Janish Jain. Thank you so much. Now I request Advocate Amul Sawant, Member, Bar Council of Maharashtra and Goa, by Mrs. Gargi Warunjikar and Mrs. Neha Deshpande.
Now I request Advocate Vijay Dihe and Advocate Akshay Kotecha to welcome Advocate Satish Deshmukh, Member, Bar Council of Maharashtra and Goa and ex-Vice Chairman of BCI. I request Mr. Yomesh Warunjikar and Mr. Siddesh Plankar to welcome Mr. Milind Thobde, Member, Bar Council of Maharashtra and Goa. I request Mrs. Warunjikar and Ms. Sonali Chavan to welcome Advocate Vivekanand Ghadge, Member, Bar Council of Maharashtra and Goa. Thank you. I request Ms. Gargi Warunjikar and Ms. Mrinmayi Khambate to welcome Advocate Sangram Desai, Member, Bar Council, Maharashtra and Goa. Now I request Mr. Yomesh Warunjikar and Mr. Nitesh Gupta to welcome Advocate Gajanan Chavan, Member, Bar Council of Maharashtra and Goa. Thank you. I request Mrs. Warunjikar and Mr. Mayur Parab to welcome Advocate Parijat Pandey, Member, Bar Council of Maharashtra and Goa. Thank you. I request Ms. Gargi Warunjikar and Mr. Shantanu Adkar to welcome Advocate Anil Gordipe, Member, Bar Council of Maharashtra and Goa. Thank you so much. Now I request Mr. Warunjikar to explain all of us the theme of this book.
Thank you, Nitesh. Honorable judges on the dais, of the dais, all dignitaries, all invitees. Ultimately, after almost 27 minutes, this felicitation came to an end. Let us give a big hand for all of them together. Thank you. I know somebody might be thinking that why so much big list, but these are the invitees who spared their valuable time. They came to Delhi, they have graced this occasion, and therefore, as a token of love and appreciation, this 27 minutes were required. I am sorry for encroaching on the valuable time of both the honorable judges. I have been called upon to say a few words about the theme of the book. Being a practicing advocate for years together, it has been noticed that there is a need to do so many good things, so many positive things, so many things which are required within the framework of the law. As a student of law, it has been noticed that always there is a scope. Always there is a scope for improvement for all stakeholders, be an advocate, be a researcher, be an academician, by whatever. by whatever name it may be called. And speaking for myself, after completion of around 22 years of a practice, I felt that now there is a time to go back to the law schools once again. And at this time, after 22 years of my practice, I got a support from my learned wife, who is also an advocate, and our both the kids. They accompanied myself. They dropped me at the examination center. I rubbed my shoulder with all other young students of law, and ultimately I was declared as a pass. Having passed that examination, after 22 years of a practice, I thought this must be a full stop. No, I was allotted a guide who is known for its so many different qualities, including the 100% accuracy, and therefore I started the next journey. The next journey was under the supervision of my guide, Dr. Uke, and I am having a complete bundle of those rough pages which are having a red color marking made by my guide. He took it, rather he compelled me to carry out all those small mistakes which are there to make it a 100% accurate thesis. From 2011 onwards, I was giving some contribution so far as this P.N.D.T Act is concerned. We are aware that nobody is saying that the technology is wrong. There are chances that the technology may be misused. There are persons who are misusing those technologies. And therefore the Act came. We are aware about the 1987 Act, which was introduced in the state of Maharashtra. We are aware about 1994 Act, which was introduced by the central government. Then the SLP in the Supreme Court, Sabu George is here because of his initiative, and the other associations like NGO like Sehat, Masoom. All those persons ultimately placed the facts and figures before the Supreme Court, and the judgment came by virtue of which now the further amendment took place in 2002-2003. Now we are almost after 20 years of that amendment, but now still there is a gap between the object which was to be achieved and the actual implementation. The person in the womb, the child in the womb, is comparatively neglected throughout the country. No doubt there are very few provisions in the Act, different Act, like you can go to the Hindu Marriage Act, you can Succession Act, you can go to the even Criminal Procedure Code. There are some provisions which are taking into consideration the child in the womb. But this framework of the Act is such that it saves those unborn girls, those unborn daughters. And therefore the commitment journey started in somewhere 2010, 2011, since when I was one of the resource person along with Advocate Varsha Deshpande and her team of a Lek Ladki Abhiyan. We were invited in different judicial academies, different courses, different universities who were giving a better knowledge about this act. They were sensitizing the public prosecutors. They were sensitizing the all different stakeholders. After having sufficient experience about this, a thought came that now there is a need to compile those thoughts and put it in the form of a research. There has to be a systematic work, and then under the guidance and supervision of my guide, I could complete this. Of course, this was not a journey which I can forget, because somebody has wisely said that the destination is not important, but the journey is more important. And I must say, all those different persons who blessed me during this entire phase of completion of the PhD, not only that, but the parents, our family members, my complete office staff, because several lawyers are also having a question mark in their mind that how Dr. Advocate UDAY Warunjikar is capable of sparing some time. What is that secret? Let me tell you what I followed. Perhaps this may be useful to the rest of all those invitees who are here. Monday to Friday, complete work in the court, being a litigation lawyer. Then Saturday was reserved for the purpose of utilization of that entire material which has been collected, digest it, read it, prepare the notes based on that, and then in the next week, start preparing small paragraphs based on, or small notes based on the whatever you have read in that week. This was a process which was going on. Of course, I was assisted by the stenos who are competent stenos in my office. I was given sufficient time by my all junior lawyers who were there at that time. Some of them are present today in this auditorium. Ultimately, they could see that I could get some time. The thesis was submitted. Ultimately, I was declared as a successful person and the PhD was awarded. I realized that I thought this must be a full stop. Again, Advocate Varsha Deshpande, Dr. Mahashabde, they came and they said that no, this can't be a full stop. You will have to publish this. Academic research and the practical aspects, these are unfortunately two different things. Unfortunately. Academicians treat that the practical aspect will be dealt with by the professionals, and academicians feel that they are living in the separate world. Vice versa must be there. All lawyers must be thinking that the academicians are living in the separate world and they don't know anything. But the time has come when this gap between the academicians and the professionals will have to be minimized. As rightly said by the anchor Nitesh and the Pravartak, that why we have started these all activities, because we feel that the gap between the theory and the practice will have to be minimized, and therefore in the future there will be few more courses which will be started. Having said about this, now this is a conversion of a thesis into the book. The thesis was submitted in 2018. So of course the postscript was most important, because almost 14 or 15 honorable judgments came from honorable judges, including the judgment of the Supreme Court also. And apart from that, 2 more legislations came, like ART and the surrogacy. So in the postscript chapter, this has been added. Ultimately, what is a basic intention behind publishing the research? Because I was just sharing with Shyam few minutes back that there is no authenticate book on the P.C.P.N.D.T. Act. There may be books about the human rights, there may be books about the gender justice, but about the P.C.P.N.D.T. there is no complete book. And let me borrow that word which has been added by Justice Oak in the foreword. I am really thrilled when Justice Oak said that this book is an encyclopedia of the P.C.P.N.D.T. I think this is the acknowledgement which I have received. I am really honored, sir. Why we choose to publish this particular book? Because even today, if we go to the Maharashtra, if we go to the Gujarat, if we go to Haryana, if we go to Rajasthan, Madhya Pradesh, Uttar Pradesh, virtually every part of the country we are facing this problem. The people were not ready to acknowledge the problem of a son preference, problem of having no mechanism to save the daughters. There was a problem about the different mindset which were there in the society. But ultimately the time came, the law has come. Now this is one of the book which I have presented before all of you. I am sure the concerned all stakeholders will take an appropriate note of this book, and I am sure this book will be utilized for saving all those daughters who are in the womb. I think this was the theme which was behind the book. Thank you. Thank you.
Thank you so much, sir. I am sure everyone is eager to see what is this book is exactly, where right now we had a short introduction of it. But before that, we have one more guest, Dr. Sadhna Mahashabde. Despite of her personal family difficulties, she made it sure that she'll be here. So I request Mrs. Warunjikar and Ms. Gargi Warunjikar to kindly welcome Dr. Sadhna Mahashabde. Thank you so much. Now I request Honorable Lordship Justice Gavai and Honorable Lordship Justice Oak and all the dignitaries on the dais to kindly present us and publish the book which all of us are waiting. Thank you so much. This book will be soon available for us. The book will be available with a discounted price. Before proceeding further, there are two more guests we missed. I request Dr. Warunjikar and Mr. Nitesh Bhutekar to kindly welcome Advocate Amit Vaid, Member of Bar Council of India. Thank you so much. Thank you so much. I again request Dr. Warunjikar and Siddesh Piyankar to kindly welcome Advocate Pratap Mehta, Advocate Pratap Mehta, Member, Bar Council of India.
Now I request Advocate Vasantrao Salunke to address the gathering.
All the dignitaries on the dais and of the dais, good evening everyone. The chief guest of today's function, Honourable Justice Bhushan Gavai, Supreme Court of India, Honourable Shri Justice Abhay Oak, Judge Supreme Court of India, Honourable Dr. Mrs. Bharati Pawar, Union Minister of State, Health and Family Welfare, Honourable Justice Chavan, Vice Chairman E-Court Committee, Supreme Court of India, Honourable Shri Manan Kumar Mishra, Chairman Bar Council of India, Shri Prashant Kumar, President Bar Association of India, and Shri Shyam Diwan, Senior Advocate and Vice President Bar Association of India, Shri Rajendra Jumap, Vice Chairman Bar Council of Maharashtra and Goa, Shri Jayantrao Zaibhave, Member Bar Council of India, and all other honorable members of Bar Council of India, Shri Dr. UDAY PRAKASH WARUNJIKAR, and all other members of the Bar Council of Maharashtra and Goa, ladies and gentlemen. Being a chairman of Bar Council of Maharashtra and Goa, I welcome all the dignitaries present on the dais and of the dais. I feel proud and fortunate to be a part of this function arranged by the Bar Council of Maharashtra and Goa and Warunjikar Institute of Rule of Law. It is a very happy event of book release ceremony written by Dr. UDAY PRAKASH WARUNJIKAR. It is released at the auspicious hands of honorable dignitaries, my Lord Justice Gavai and my Lord Justice Oak sir. My only colleague member of Bar Council, who is a doctorate and a great academician amongst the bar councillors who have written this book, The Gender Justice, Human Rights and PCI and P.N.D.T Act 1994, Critical Appraisal of Statutory and Judicial Perspectives. Mr. Warunjikar is also author of other 3 books on law. Not only this, Mrs. Warunjikar, our Bhabhi, is also a author of one of the law books. Dr. Uday is having versatile personality. He is a good orator, player, writer, and after all, a good human being. Dr. Uday has spent his valuable time for thesis on his busy schedule of practice and daily darshan on media. He covered amongst almost angles of the subject, which shows his deep sense of law. I am sure that the book written by Dr. Uday Warunjikar, published today, would be helpful to the law practitioners, lecturers, academicians, and law students. I may refer here that this is the only starting. This is the rising light, the UDAY PRAKASH. Now still, the sun has to blaze. Ajun सूर्य तळपायचा आहे. I congratulate author Dr. UDAY PRAKASH WARUNJIKAR and wish him great success in future to write many books on law. I am thankful to all the dignitaries on the dais and of the dais of their kind presence on this auspicious occasion. Thank you. Jai Hind, Jai Maharashtra.
Thank you so much, sir. Now I request Advocate Jain Bhave sir to kindly share his thoughts.
Honourable Justice Bhushan Gavai Sahib, Honourable Justice Abhay Oak Sahib, Honourable Justice R.C. Chavan sir, Dr. Uday Warunjikar, Honourable Manan Kumar Mishra, Chairman Bar Council of India, all dignitaries present on the dais, and all respectable brothers and sisters. I will not take your time because I am not a scholar on the subject on which today's book has been released. But I am particularly here to give my all best wishes to Dr. Uday Warunjikar, Mrs. Warunjikar and his entire family for their hard work. In fact, when in the morning he was showing me this big book and he was telling that for review you will have to read this book, I skillfully avoided that and only I have taken the minute-to-minute program. But now I have seen the book, just overlook the book, and he has not followed my one advice. In fact, I have advised him that you should write on the last page of the book what is your exactly source of energy and what exactly you eat and what exactly you drink. Because we know he don't eat non-veg and he's non-drinker. So how he gets such a energy? All the honorable lordships are there. He practices practically in all courts of Bombay High Court. Then he rushed to the consumer court. Then if possible he goes to MAT. Then he tried to go to the CAT and everywhere. And he was talking about his planning of a week. But I don't know how he moved totally towards the Maharashtra. He will go to the tribal area of Surgana. He will go to the Satara. He will go to the Nagar. And his another ability is that whenever he goes, he promises that he is from that particular area and people believes him. And therefore, all this, yes. And therefore, I was requesting him that you should write your source of all this energy into the last page of the book. That will be more encouraging. I think, Dr. Uday, you will follow my advice on a next book, and at least some of your energy sources will be disclosed. It's really a great effort to write a subject on such a difficult topic. He has mentioned that, forward Honorable Justice Abhay Oak has said that The book is an encyclopedia on the particular topic. We all know that, in fact, Dr. UDAY Prakash Warunjikar himself is an encyclopedia of an advocacy. And when he writes one book, he was repeatedly, now he was just addressing us and he was repeatedly talking about the full stop. I must tell you that it's a question before the Bar Council when he starts speaking, how to stop him is a question. And perhaps honorable judges also have a same feeling. Honorable Justice Abhay Oak and Honorable Justice Gavai is here. And all the colleagues, senior colleagues like Sham Diwan and all are here. It's really energetic. And for that, Dr. UDAY Prakash, I will request you that the subject of this gender discrimination on which you have written a book with a hard work, in fact, it's a subject of a very concern in a society. But that society is not this society who will read this book in your language. My request will be that that society lives into the corners of the Maharashtra, somewhere tribals, somewhere very poor peoples, and in fact, if at all female is not to be born, it is not to be born in that particular herds and not in the society who will read this book. So you are a socially aware person, and my request to you is that, and also I have to communicate that Dr. Bharati Pawar has also given you the best wishes. Her PA just telephoned me and communicated, and it is their request, all of them, that this book must be in a Marathi. This law should be understood by the people who, for whom this real this concern of gender discrimination is there, and you will do that job. For that, I wish my all best wishes to you. I am sure that this is a beginning of your 100 books. You will complete that. All energy is reserved for that, and keep this energy, keep this enthusiasm, and also the Bar Council will be always in support of you. Today, in fact, when this function was to be organized in Delhi, it was a function of Warunjikar Institute. But we all Bar Councillor, with advice of our chairman Manan Kumar Mishra ji, said that we are coming with this concept under the leadership of Honourable Justice Gavai. Now we are coming with a university, in which university the research should be done by the practicing lawyers after completing their 20 years practice, after completing their 25 years practice, because law has become a bookish. It has become an academic subject only. We have to give a practical angle, the real perception of real happening of in a society about the law, and if that is to be done, it is only the practicing experienced lawyer who should make the research on the law, and that research is the real research. And the starting batsman is, of course, our Sachin Tendulkar, UDAY Warunjikar. This particular concept will be taken forward even by the State Bar Council of Maharashtra, other bar councils who are present here, and also Bar Council of India, and through our new university, which is going to be there in a Goa research in a short time. In that university, we will try to promote these types of research throughout the country, and that will be the great achievement in the development of the law. I again wish my all best wishes, particularly to Dr. UDAY Warunjikar and also to Warunjikar Vaini for their great support. Thank you very much.
Thank you, Advocate Zaibal sir. Now I request Senior Advocate Mr. Sham Diwan to address the gathering.
A very good evening to all of you, Justice Gavai, Justice Oak, the hero of the day, my good friend UDAY Warunjikar. This is a really special moment, and I must begin by congratulating you on coming up with this excellent publication. I just have had a look at it and glanced over it for just a few minutes, and I find that there are so many perspectives which enrich this book. There is an international perspective. There is a very, very detailed perspective of statistics and material from across the states. And there's a clearly, very clearly, a practitioner's insight into the whole thing. Because when I was looking at the book, it wasn't that the Bombay High Court said this or the Supreme Court said that. He has referred to the benches. He's given you the names of the judges, And there are very interesting footnotes also. It's very difficult to write a book with interesting footnotes. But this one has some interesting footnotes because you immediately have at the source as to when this particular person, when he or she was a member of the High Court or of the Supreme Court, and even details as to when he or she was a Chief Justice, etc. So my compliments and congratulations to you on this enormous and wonderful academic exercise. I think there's lots of lessons for each one of us. We must each one, I think, set apart some time. I don't know whether I'm going to spare my Saturdays, but certainly some time for academic thought. I was reminded that there is a tradition in certain other jurisdictions where counsels, not necessarily senior counsels, but advocates, and I think at some level the Supreme Court judgment, which despite the company I completely disagree with regard to how a senior advocate should be designated. But anyway, we have that judgment and hopefully at some point we'll overcome it. But so long as it is there, it recognizes one good element, which is it encourages academic writing amongst those who want to apply for the purposes of designation. And I think in some jurisdictions across the world, you are required to set apart some time. So you have articles, I mean, the tradition, for example, in the United Kingdom is that you have the Law Quarterly Review and you have the Modern Law Review, for example, or Public Law. Similarly, you have journals in Australia and several other Commonwealth jurisdictions. And when you see the authors in these journals, you find that they are often practitioners of the bar. So it's not just the academic journals where professors are writing, where scholars are writing, but you have certain journals across these Commonwealth jurisdictions where practitioners take the time out, analyze a subject, and then put it out. So I think the example which Dr. Warunjikar has given us, and the lead and the example which he gives us, is something which we should all try and replicate. I'm not sure whether there are medical doctors in this particular gathering, but I was this subject has a very different perspective. Just as your perspective changes when you're on the bench, the perspective changes when you're on the bar. But there are some tremendous practical issues also which inform the debate as far as the working of this act is concerned. And I'll share with you a friend of mine. I mean, he's a well-known doctor in Mumbai, and he had a real practical problem. The practical problem was that he had a sonography machine. And, you know, as our population gets healthier and many of us grow to and age gracefully to ages of 90 and 90 plus, it's too much of a task to to go to a doctor for a visit just to get a sonography. And so there are these mobile sonography machines, but they pose such a huge practical problem because to try and square it with the provisions of the Act and to try and get it done in terms of, you know, the registrations which are there and exactly where it is, it raises a very, very difficult issue. And I mean, the problem which the doctor was projecting to me is that if you strictly follow the law, essentially some of these particular types of patients will find it very, very difficult to obtain and get a sonography. So that's one element. I haven't had a chance to deeply study it, but if you see the prosecutions, and I'm sure Uday has looked at this, if you see the prosecutions across the country under this particular act, some of them are absolutely egregious. I mean, when you read the facts, some chap like me who doesn't do much criminal law gets completely shaken to the bone when you see the facts and what the FIR, etc. Reveals and what even the trial courts have recorded in their judgments, and of course the appellate courts. But keeping that aside, you find that the statistics reveal that almost all, I would say, reckon more than 90% of the prosecutions, at least in Maharashtra, are for the purposes of not maintaining registers and records. Now, I don't think that is the purpose of this act, personally. I mean, the purpose and the object of this act is to move us as a society and in our thinking in a different direction, so that we ensure that, as Uday mentioned, the unborn child, particularly the unborn girl child, is not disadvantaged and is welcomed with open arms. So that's something for really the administration to think about. But I conclude by again congratulating Uday on this magnificent publication. I want to just warn him, however, that when you write a book which is popular and which attains the status of an encyclopedia, you are completely, you're compelled to come out with a newer edition every few years. And that becomes a task in itself. And I'm sure I congratulate you on this, and I look forward to newer editions, both in this field and in other subjects. Thank you very, very much.
Thank you so much, sir. Now, I request Advocate Prashant Kumar, sir, to kindly address us.
Thank you. Honorable Justice Gavai, Honorable Justice Oak, Honorable Justice Chavan, my friends and colleagues on the dais and off the dais, and all the dignitaries. This journey of Uday, culminating in publication of his thesis as a book, not only that he has sacrificed his Saturdays, he has devoted time, he has devoted his energies. It is the outcome of enormous energy and passion. So much passion that a subject which otherwise, when you think about publishing a book or doing research, is not very popular because it is technical, it requires a lot of deep study and research, it requires gathering of a lot of information and data, the analysis. So it's a Herculean task, and that too for a practicing advocate. And I congratulate Uday for having undertaken it. So once he was awarded the PhD under able guidance of his guide, Professor Uke, whom we felicitated last year on Lawyers of India Day. We celebrate in Bar Association of India the birthday of Dr. Rajendra Prasad, the first president of Republic of India, who was a lawyer, a very tall lawyer in his own right, and who inaugurated the Bar Association of India as Lawyers of India Day. And apart from felicitating and recognizing lawyers, we also felicitate at least one legal academic on that day. But today, you fit in both the categories. It's not that you practice in courts, you are able to spare time to attend conferences in India and abroad. You are able to also go to various law colleges to deliver lectures as a part-time lecturer, as a guest lecturer. So this is what is a full spectrum of what one can call service to law or service to the profession. And to add to it that at least more than half a century of juniors you have produced during your practice, which is also something which is bounden duty of a successful practitioner. Now, once having earned the doctorate, the next step was that to get it published. And mind you, this is not a subject for which publishers will line up easily. They see that how many libraries are going to order it, how many practitioners may belong to this field. So Uday also spoke with me, we spoke to a number of publishers, and then ultimately it was decided that it should be self-published rather than going and lying as a manuscript with publishers who say, okay, we will look into it, but then ultimately they don't see that their commercial motive will be served. So again, he has not only done this labor, he has also invested his time and money to publish this, without any profit motive, for which we must again thank him. Again, as I say, and I had been assisting in publication of Indian Advocate, which is the journal of the Bar Association of India, and is looked upon world over to have some significant articles and developments published in Indian and international legal developments. And now with my colleague Anandita, who is the General Secretary and herself has been an academic and has done her PhD. It's a long struggle for us to make the practitioners write articles. So it's a quarterly, but we feel that we have achieved something if we are able to bring out that journal annually. Because we can't sacrifice the quality for which the journal is known, the standards for which the journal is known, but to convince the practitioners to write articles for the journal is a very difficult task. And even though, as Shyam has pointed out, the requirement for publication of articles and all for designation, we were flooded with requests that our article be published, but the quality is at best suitable to be published in a newspaper or in a periodical, but nothing which is backed by a well thought out legal analysis and research on any topic. So we got huge number of articles, but most of them did not come up to the level which we expect. And another significant thing is even from known practitioners who otherwise are very good, are very successful, and very erudite, the culture of writing and coming up with an original, well-written, well-thought-out piece, either in the form of article and book, is not just there. So another thing which Bar Association of India, after analyzing articles, is that we are purchasing a software so that there is no plagiarism. Because so many of unacknowledged portions from others' writings and publications are just reproduced. So I think one of the endeavors has to be to encourage research, but to encourage original research and also impart the training on how the discipline of original writing and research in terms of publication is to be followed, how acknowledgements are to be given. And I think that will serve to create a body of well-researched, well-informed, legal, academic output from the practitioners, which I'm sorry to say, we are having almost a drought in terms of quality, if not quantity. So Uday, for you to do all this, and when to talk about passion, I know I'm taking time. When we went to China, his first question was, introduce me to somebody who knows how the one-child policy is implemented in China. What has been its impact? So I had one of the China Law Society had provided a lawyer to us who was interpreting. And she is now one of the top practitioners in intellectual property law. So she came forward and said, yes, I can introduce. And let me tell you, I am a missing girl child. Because she was born in rural China, and because of the restriction of one-child norm, she was not reported in the birth register. And that's why all the deprivations and disentitlements which come along with it, and still she made it. Then again, another curiosity of his, when we went to Brazil to attend the BRICS forum, his question was, can anybody educate me about what is the gender balance here? Though overall gender balance is good in Brazil, and it's a Catholic country. So his question was that, how this is done, whether there is a discrimination. So there also we found ultimately in the pockets which are poor, which are called favelas, which surround Sao Paulo, Rio de Janeiro, and other cities, female infanticide is prevalent. So this book, which Justice Oak has labeled as encyclopedia, by merging the themes of human rights, gender justice, and all these issues, has created a niche of its own, which will not only be useful for the practitioners, for the doctors, for the general public. I'm very sure, and I know, he's so enthusiastic, he is going to have several journeys with me across the world. He will present this book, and he will keep this movement of recognizing these deprivations, that even the advancement of technology can inure to the detriment of a girl child, can lead to gender injustice, can lead to female infanticide. So here, there is a technological advancement to serve the mankind, but its usage is having a pernicious aspect. So that is what a new thinking which has been cultivated by Uday, and I think this book, it needs to be not only read and consumed, it should have a very good circulation, and from Bar Association of India, we'll try to work it out that how we can make this book reach all the universities and all the bookstores, with what kind of collaborations, because otherwise, with solely a commercial profit-making objective of a publisher, it will lie in the go down. So Uday, all the congratulations and accolades to you, which are very well deserved. Please take mine, add mine to them. Thank you very much.
Thank you, Advocate Prashant Kumar, sir. Now I request Mr. Manan Kumar Mishra, Senior Advocate and Chairman of Bar Council of India, to share his thoughts.
Honourable Mr. Justice B.R. Gavai, Honourable Mr. Justice Abhay Oak, Honourable Mr. Justice R.C. Chavan, the Chairman of the State Bar Council of Maharashtra and Goa, Mr. Syam Diwan, Mr. Prashant Kumar, Mr. Jain Abhay, Member Bar Council of India, the Honourable Members of Bar Council of India and State Bar Council of Maharashtra and Goa, my dear colleagues, ladies and gentlemen. At the very outset of this program, we heard about the theme behind Warunjikar Institute of Rule of Law. The objects we all appreciated. And the aim and object with which this subject of research my friend Dr. Warunjikar has chosen, that's really is to be appreciated by all. See, the research work by a young lawyer, a student in continuation of his studies, that is a common thing. But after 20 years of practice, an advocate, that too a BG advocate, Mr. Jai Bhavesh informed us that all the times Mr. Warunjikar is BG in some court, in some tribunal. So for a BG advocate to undertake this research work is really surprising. Sir, being the chairman of Bar Council of India, since we regulate the legal education, I got so many offers. Mishra ji, you being the chairman, some of the VCs of private universities, they said, why don't you also get a PhD? I said that I have no time to study so much, files and this BCI work, that is so overladen that I can't. No, you will not have to do anything. The persons are there to write the thesis. You will be simply putting your signature. Today I think that by refusing those offers, really, I was right. Some of the university people, they said that we will confer on you the PhD. Why should, when I don't deserve, why should I say that I am a Dr. Manan Kumar Mishra? Simple Manan Kumar Mishra is enough. See, the subject Mr. Warunjikar has chosen, that goes to the very root of some social problems. This female poeticide, it's a big problem. Just now, after release of the book, I was going through a few paragraphs, few chapters of this. One thing Mr. Warunjikar has discussed in detail. The acts we are passing daily, laws are coming, but Mr. Warunjikar has highlighted what are the real challenges, what are the difficulties in the implementation of this act, the provisions of the act. That, when you will go through the book, you will really appreciate the case laws he has discussed. Mr. Syam Devanji, he highlighted how has he, and in details he has discussed the case laws on the relevant points on the subject concerned. We also do the research work. The lawyers who are practicing, what we will do this research work on this book only. Whenever it will be needed, some case will come to us with regard to this P.N.D.T Act. We will, without wasting any time, we'll pick that book from our library, the book written by Mr. Warunjikar, and we will take out certain citations and certain provisions, and we will take the help. So that much of research work the lawyers do. Really, the Bar Council of Maharashtra and Goa has done a very good job. Mr. Jai Bhave, he told that we want that this program should be held in Delhi. The Honourable Judges of Supreme Court, they should be there. I said, it's very good. We welcome that step. Because rarely an advocate, he dares to go for research works or writing a book. So, Mr. Warunjikar, heartiest congratulations to you. I, on behalf of the legal fraternity of the country, I wish you all success in life, and I hope that within 1 or 2 years, 2, 3 more books like this will come and we'll be releasing George. This Bar Council of Maharashtra and Goa, the entire Bar Council has come to Delhi in order to greet, in order to congratulate, and in order to highlight this publication of book. Really, it's a very appreciable work of the Maharashtra and Goa Bar Council. I congratulate the State Bar Council also. Thank you all.
Thank you so much, sir. Now, I request Honorable Justice R.C. Chavan, sir, to kindly address.
Honorable Shri Justice Gavai, Honorable Shri Justice Oak, Honored Chairman and members of the Bar Council of India and Bar Council of Maharashtra and Goa, Dr. Warunjikar, his guide Dr. Uke, and my dear friends. As Justice Oak has mentioned in the forward, Dr. Warunjikar deserves to be complimented for publishing his thesis because it's an encyclopedia. It contains everything. Apart from the results of his research and useful thought-provoking suggestions, legal fraternity will not be required to search for relevant information anywhere else. You can find everything at one place. As the previous speakers spoke, this needs to be updated from time to time. I would urge Dr. Warunjikar to bring out an e-edition so that it can be updated without taking the trouble of printing it again and again. This will help particularly the workers who are working in the field to have updated information on what is the law on the subject at the relevant point of time. True, there are many good law reporters, but they don't analyze and update law on a particular subject. If Dr. Warunjikar takes up this task, and I suppose he has a very good support team, so this is doable. This book is published by Dr. Warunjikar Institute of Rule of Law. And therefore, as also, because of what Advocate Diwan said, I'm tempted to say something. The law exists for those who want to follow it. It doesn't exist for those who don't want to follow it. For them, law doesn't exist. So therefore, reducing P.N.D.T Act to the old Essential Commodities Act, where not displaying stock position on the board was an offense, is not new to the field of law. We know that these things happen. If you don't want to follow the law, you can always have a van in which sonography machines are kept. Machines which are not registered anywhere. You can provide service to people who want them. But then, the number of prosecutions, I took up some figures from the National Judicial Data Grid, about which we, E-Committee, are proud. I don't know whether the figures are correct or not, but they present a grim picture. Apart from the time taken in bringing culprits to the book, the time taken in trials is alarming. Out of 16,786 cases which are listed in the National Judicial Data Grid, trials as well as appeals, a good 13,705 are pending for more than 2 to 5 years. And 2,274 are pending for 5 to 10 years. As if this is not enough, few convictions are handed down, the rate is hardly 10%. And even if those 10% convictions, when there is an appeal takes years. Strength or weakness of a chain is measured by its weakest link. And unfortunately, my gods may forgive me for saying this, I have been a part of the system. The judiciary is that weakest link. We take interminably long time to bring culprits to book. Rule of law has broken down because we don't serve just deserts to people in nick of time. The fact is that all crooks and criminals proclaim from rooftops that they have full confidence in the judicial system. Whereas a former Chief Justice of India and now a member of Parliament expresses his apprehensions about the efficacy of the system. Even if we were to ignore what the former Chief Justice of India said, do we not tell time and again, officially, to people who come to courts, to settle their disputes outside the courts for less than what they are entitled to, adding that our system of justice is time-consuming with no guarantee of results. People ask, why not go to Bahubalis? They deliver quick results. This Dr. Warunjikar is talking of and pioneering an effort by having an institute of rule of law. Let us give a thought to what is rule of law, what is the position of rule of law in India. While the Rome of rule of law is burning, heroes of the system, like me, are busy fiddling with figures of pendency. We hold them as a fear to the common man, saying that no, don't come to the court. Settle your disputes elsewhere. What is that huge pendency? It's just 5 crore cases. In a country of 140 crores, it's just 5 crore cases. And I'm sure that at least 1 crore of them may be false. Not qualifying to be cases as such. And these cases are to be dealt with by 20,000 courts. We have got 20,000 judicial officers in the country, helped by a strong bar. Manan Kumar ji, your bar is 20 lakhs, I suppose, enrolled. Okay. Let us say, take that only 10 lakhs are actually practicing. So it comes to just 2,500 cases per court. Is it too much? Is it not manageable? We want to bring in rule of law, reinforce rule of law. We have to put our act in order. We have to clear our stables first. Every year, about 1 lakh youngsters join the bar with dreams in their eyes. In 2 or 3 years of practice, they forget all those dreams. They realize that nothing really happens here. Opportunities for making a decent living alone will attract good people to litigation. Our national law schools produce law graduates who don't come to courts, who go elsewhere. All this doesn't augur well for the system, for the health of the system. If, doctor, your concern is about enforcement of rule of law, please think about this. As far as P.N.D.T is also concerned, yet it not be reduced to the old EC Act where we fudge figures, the registers, which may be manipulated, kept wrongly, etc. What is wanted is the result on the ground, the change in the sex ratio. And that is not happening. Varshaji has been in the forefront of this battle for a very long time. And she will agree that the whole thing breaks down when matters come to the courts. So, all of you are legal professionals. Our wherewithal, our survival depends on this profession. Our survival depends on the success of rule of law. If we don't think of that, then possibly everything will be lost. I just thought that I would take this opportunity to remind you of the miserable state of rule of law today, because the book is published by an institute called Dr. Warunjikar's Institute of Rule of Law. Please give a thought to this. Thank you.
Thank you so much, sir. I'm sure that Warunjikar Institute of Rule of Law will definitely put all the efforts to achieve the advice given by Honourable Justice R.C. Chavan. Now I request Honourable Justice Abhay Oak to kindly address the gathering.
My esteemed senior colleague, Justice Bhushan Gavai, Shri Mishra, Chairman of the Bar Council of India, Shri Vasantrao Salunke, Chairman of the Bar Council of Maharashtra and Goa, Shri Prashant Kumar, President, Bar Association of India, Senior Advocate Sham Diwan, other senior advocates, large number of members of the Bar Council of India and Bar Council of Maharashtra and Goa who are present here, Justice R.C. Chavan, young members of the bar and friends. I am not supposed to speak much because I have written a foreword to this book. But since Mr. Warunjikar has invited me to this function, I am going to take 10 minutes of your valuable time today. PC and P.N.D.T Act is a very, very serious subject. It is a very serious legislation. It is very important legislation for our society. Before I express my few thoughts about this subject, I want to begin on a lighter note. I have read some of the books written by UDAY Warunjikar, some of the articles I have read. He has respect for women, and that respect was reflected today when he referred to Mrs. Warunjikar as his learned wife. When Mr. Pathak came to me with the invitation, I started wondering, what is this Warunjikar Institute of Rule of Law? Fortunately, introduction was given by one of the earlier speakers. In the introduction, the speaker said that this institute proposes to file public interest litigations. Mr. Warunjikar, I hope that this is not a warning to the judges of the Bombay High Court. But the objects are very important. Justice R.C. Chavan dealt with this subject of rule of law. The objects are very important, and I
personally feel that you must add one more object to that, your institute. The object should be to start awareness campaign in our society about all the social welfare legislations. The object of this institute is very noble. Only one small piece of advice which I want to give to Mr. Warunjikar. With the passage of time, he'll have to ensure that word institute remains in the name and it should not become Warunjikar's rule of law. That precaution he has to take. Third thing which I want to say in lighter vein, what Mr. Bhave said, that Mr. Warunjikar is unstoppable. And he referred to both of us, myself and my learned senior colleague, Justice Bhushan Gavai. I take liberty of saying something, not only on my behalf, but on behalf of my friend also, my esteemed senior colleague. As far as two of us are concerned, he was never unstoppable. Because we always ensured that he retains his great energy to go and argue before the other benches. So we always allowed him to conserve his energy. So I must clarify, Mr. Bhave, that he was not unstoppable. Now coming to the today's subject. Now we'll be completing 75 years of Indian independence, and we have so many social welfare legislations in place. I find that one of the main reasons why these legislations could not be effectively implemented is lack of public awareness about these legislations. About this very legislation, I want to share my own experience with you. When I was the executive chairperson of the Maharashtra Legal Services Authority, we had arranged 3 huge legal services camp in 3 different remote areas of Maharashtra. One was in Shahpur Taluka in Thane district, other was in a very remote Naxalite dominated area in Chandrapur district, and third was in a very remote village in P.N.D.T district. In one of the 3 camps, as a part of services to be rendered to the common man, we had got the machine for conducting the test on pregnant women, the ultrasound test. I must hasten to clarify that the camp was near a health center of the government, so all licenses, all permissions were in place. The reason was the local collector had told us that many women, pregnant women residing in rural areas, were advised to undergo this ultrasound test, sonography as we call it. But due to poverty, due to inaccessibility, they could not undergo those tests. So idea was to render that service to pregnant women in these remote areas. And I was told that good 70 or 80 pregnant women had registered for this. I requested some of the women paralegal volunteers to interact with these women. I wanted to know their reaction. At the end of the day, I had conversation with some of the women paralegal volunteers. All of them told me only one thing. Practically every woman who had come there to undergo that test asked those paralegal volunteers whether I will know the sex of the fetus. This is the level of awareness we have about this statute. I am talking about 2019. Few years back, about 4 or 5 years back, I attended a seminar, day-long seminar arranged by the Gynecologist Association in Mumbai. Every year they have these legal workshops. The subject given to me was totally different, but there was interactive session. Most of the queries which were asked to me were about this act. I felt very sad after hearing those queries. I found that most of them were not aware about the elementary provisions of this act. Now, this act is almost 38 years old now, 1994 Act. Therefore, the point which I want to make is that unless there is a public awareness at grassroots levels in our society, implementation of this law, effective implementation, I am saying, will be something which is impossible. Many of today's speakers have referred to what Dr. Warunjikar has said in the book. The most important part of this book which appealed to me was the suggestions which he has made to the Parliament about various amendments to not only the Act but also to the rules. One of the suggestions made by him is that, like many other welfare statutes, there should be a provision prescribing timeline for disposal of trials as well as appeals and revisions, etc., arising out of prosecutions under this Act. Here I want to respond to what Justice R.C. Chavan said a few minutes back. As a judge of the Bombay High Court, as a Chief Justice of Karnataka High Court, and now as a judge of the Supreme Court, on public platforms, I accepted one thing, that judiciary, just like any other institution in this world, it is not infallible. The judiciary has many flaws, judiciary has many drawbacks. But one aspect I want to clarify about the issue of pendency. There are many statutes where such provisions are there. Hindu Marriage Act provides for, I think, 6 months. Many other statutes are there. Case should be disposed of within 6 months. And therefore, Mr. Warunjikar is right when he suggested that there should be a similar provision in this Act. But there is a practical problem which I want all of you to understand. These are all ideal provisions. Case should be disposed of within 6 months, case should be disposed of within 1 year, appeal should be disposed of, say, within 1 year. But we don't live in an ideal world as far as judiciary is concerned. In 2002, Supreme Court passed an order that within span of 10 years, the just to population ratio in our country should be increased to 50 per million, 50 per 10 lakhs. But unfortunately, as all of us know, in December 21, the Honourable Law Minister told the Parliament that the ratio today in 2021, end of 2021, is only 21.13. We talk about early disposal of cases. We talk about what happens in many developed countries, especially dealing with such kind of legislations. But take case of any developed country, you will find the just to population ratio is much above 50. I am not defending the judicial officers or the judges who are part of this institution. But this practical aspect we have to understand. The other practical aspect is lack of proper infrastructure. Today we have a situation that our trial court judges and district court judges is the only class of public servants who have not been given benefit of 7th pay commission. There are difficulties and difficulties. Of course, I am not defending the system. I again say that system is not infallible at all. There are flaws in the system. But when we talk about early disposal of cases, we have to remember this, a very crucial aspect of just to population ratio. There are other very important suggestions made by Dr. Warunjikar. I'm sure all of you are going to read that book. Those suggestions are essentially to plug the loopholes in the statute. Warunjikar had told me that the Honourable Minister is going to attend this function. Today, the most powerful people in legal profession are here. That shows how powerful Mr. Warunjikar is. Chairman of the Bar Council of India, President of the Bar Association of India, and the Chairman of the Bar Council of Maharashtra and Goa. I'll appeal to these three powerful men to convey to the Honourable Minister or the concerned department the concerns which are expressed by Dr. Warunjikar in this book. The suggestions which he has made about the loopholes in the statute. Very rarely that when a lawyer writes a book on such a legislation, social welfare legislation, he makes this attempt to come out with suggestions should be taken note of by legislature. It is very important for all of us who are present here to convey the views expressed by Dr. Warunjikar to the right people. Like any other social welfare legislation, it requires constant updation. Our society keeps on changing. Only after we start implementing such legislation that we know where we are going wrong. There are again infrastructural issues. Mr. Shyam Diwan was right when he pointed out that our agencies, the government agencies, have not understood the real importance, the real core issues in this act, and therefore all these prosecutions we find are about non-maintenance of record, etc. Justice Chavan rightly referred to the Essential Commodities Act. And he's right when he said that this act should not become a legislation like this Essential Commodities Act. Lastly, before I close, because I must give sufficient time to my esteemed senior colleague to address you, on behalf of all of us, I compliment Dr. Warunjikar for the great work done by him, and he deserves a lot of applause for this. Thank you very much.
Thank you, Lordship Justice Oak. We will certainly work on Lordship's suggestion on starting the campaign for social awareness, not about this act also, but all other social welfare acts. Now I request Lordship Justice Gavai to address us.
My very dear friend, Justice Abhay, I did not call him colleague because we have been colleagues only for 20 years or so. We have been friends for the last 37 years. Justice R.C. Chavan, the President, Chairman of Bar Council of India and Goa, Shri Manan Kumar Mishra, Chairman of Bar Council of Maharashtra and Goa, Shri Vasantrao Salunke, Advocate Shri Prashant Kumar, dear friend, Senior Advocate Shri Shyam Mehta, Shyam Diwan, sorry. I think I'm confusing, I also confused with Mr. Manan Kumar Mishra. Shri Jayant Jayabave, the member of Bar Council of India, Shri Rajendra Umak, the Vice Chairman of Bar Council of Maharashtra and Goa, all the office bearers of the Bar Council of India, the office bearers of Bar Council of Maharashtra and Goa, my last partner, bench partner in Bombay High Court, Shri Dama Sheshadri Naidu, he was re-christened today, Vice Chancellor of the Maharashtra Law University, Mumbai, and guide of Dr. Warunjikar, Dr. Dilip Uike, and last but not the least, Dr. UDAY PRAKASH and his learned wife. It's a great pleasure for me to be with you all this evening on the release of Dr. Warunjikar's work on the Gender Justice, Human Rights, PC and P.N.D.T Act, 1994. After 7 and 8 speakers have spoken on the topic, I'm reminded of daily hearings in the court when 3 or 4 senior counsels are engaged in one matter on one side. After the leading counsel is over with his argument, the second counsel will begin with the sentence, I'm supporting the arguments advanced by so and so, and I assure your lordship that I will not repeat a sentence. I can assure you that. As Jayant Jayabave has rightly said, UDAY PRAKASH is full of energies. When a couple of years back, I was invited by Dr. Uike when he was Dean of the Law Faculty of Pune University to address on some subject on the Constitution of India. After the function was over, we were having lunch and I just came across Dr. Warunjikar and I asked him, how come you are here? So I came to know that he had started his research and Dr. VK was his guide. Little I did know that point of time that I will get an opportunity to be with all you on the release of the same subject. Dr. Warunjikar is a versatile personality. As Jayant Bhave said, we don't know from where his energy comes. Last month when we had the members of the Bar Council of India, the chairman and the others, we had gone to Goa in connection with the International Law School and the International Arbitration to be established at Goa. And also, because it coincided with opening of the office of Bar Council of Maharashtra and Goa at the Panji bench. After the function was over, the Honourable Chief Justice of the Bombay High Court, Mr. Dipankar Datta, and we were all sitting having tea. And Mr. Sarunke raised an issue, Chief Sabo, हमारे औरंगाबाद के chambers का क्या हुआ? And the reply came, अरे वारुंजकर साहब कहाँ है? बॉम्बे हाईकोर्ट का कोई भी अगर प्रॉब्लम रहा तो और हमारे पास आए हैं और हमने वो प्रॉब्लम सॉल्व किया नहीं, ऐसा हो सकता है क्या? तो ही represent the entire Bombay High Court, Bar, the Bar Council of India, and so therefore we can see that as Justice Oak said that whether stoppable or not stoppable, but a person with full energies, when he argues a case, we can hear his arguments even if he is arguing in an adjoining courtroom. He has chosen a very important subject. I would not like to dwell much because the earlier speakers have already given their compliments. They applauded him for the wonderful work that he has done. In his foreword, or in his introduction, he has stated that he is devoting this book to his mother, Vaishali alias Asha, and all Nakoshis. Nakosh is a Marathi word, and it means all those unwarranted. And therefore, the theme of the work is hitting at the gender discrimination which our culture witnessed for centuries together. All of us know that at one point of time, women were even considered at a lower pedestal than the untouchables. We know that the work done by Savitribai Phule and Mahatma Jyotiba Phule, which in the 17th century opened the doors of education for women for the first time. There were prevalent systems. A woman, after the death of her husband, had to do sati. We had child marriage. Then the widows, after the death of their husband, were disfigured. But parallelly, we also had social reformers like Mahatma Jyotiba Phule, Savitribai Phule, Raja Ram Mohan Rai, Dayanand Saraswati, Tarabai Shinde and all, who fought for the evils in the society, and as a result of which, various enactments were also enacted in the British India. Dr. Warunjikar has taken us to all this history in his book, the legislative enactments made by the British India. Thereafter, the constitutional perspectives insofar as human rights and gender justice are concerned, various articles in the Constitution which have been given wider meaning, and Article 21 stands at the epitome of that, to recognize various rights to be the human rights. And therefore, as rightly observed by my dear friend Justice Abhay, it will not be only an encyclopedia on the subject, but also a guiding work for all those lawyers, judges in discharging their duties. As Justice Oak has observed that when we came here, we were somewhat confused as to what is WIORL, and then when the introduction, we were told that it is Warunjikar Institute of Rule of Law. As Mr. Prashant Kumar has said, that there is already a Warunjikar Institute of Law which has produced not less than 50 lawyers, and it's a good idea that he has decided to start this institute so as to promote the concept of rule of law. As all of us know that our Constitution itself recognizes a rule of law. Article 14 is based on that. And I'm sure that whatever, I don't have the exact blueprint of the plans that Dr. Warunjikar has for this concept, but as Jayan Gavai had said, that in the proposed institute at Goa, they would like to have the senior lawyers, the experienced lawyers, research on various topics which would be helpful for the country, for the society, for the legal system. Sam Diwan observed about some judgment which recognizes the necessity to have some research work, and that too published. There's a debate on that, because with lawyers like Sam Diwan, they must not be finding even time to have 4 or 5 hours peaceful sleep, and to find time to have research. In any case, rule of law is the one which I don't think that anybody can dispute. The predominance of rule of law has to be there. Justice Chavan made certain comments about the pendency and the rule of law. He also referred to some statement made by one of the Honourable former Chief Justice of this court. It may not be appropriate for me to speak much on that, but unfortunately, recently it has become a system that when one comes out of the system, he started criticizing the system. It's not applicable to Chavan, to Justice Chavan. I must make it very clear, because even after his retirement, we are taking his contribution for finding out solutions in various issues concerning dependency of various criminal cases and all that, and he has been contributing it. But I would also like to ask Justice Chavan as to whether he would also endorse another statement made by the same person, which had become viral on video. He has been a part of the judiciary for more than 40 years. He is a person who represented the district judiciary in Maharashtra, and I'm sure that at least that statement to which I have made reference, he would disagree. And therefore, though the concern shown by him is right, but it may not be appropriate to criticize the judiciary and sorry to say, have a very pedantic approach. Everybody, the judges, the lawyers, in their own way, are trying to contribute to see to it that the pendency is reduced. As Justice Chavan is aware, one of such measures was the orders passed by this court for finding out solutions for the huge pendency of 138 cases. Even in many of the cases, even the notices are not served, and when that matter came up before us last week, in the city of Jodhpur, there are 20 lakh 138 cases pending. Part of that blame must also go to the legislation, because it is the enactment which primarily brought a civil dispute into a criminal one. But when we compare ourselves with the neighboring jurisdictions, which were born almost at the same time, and maybe one of the countries which parted out of that in 70s, the situation, I must say, with pride, that is much, much better in India when we compare ourselves with the other neighboring jurisdictions. And therefore, the solution has to be found. Solution has to be found by the legislature, by the executive, by the judiciary, sitting together. As rightly pointed out by Justice Oak, the ratio of population to judge in India is one of the lowest. When it was recommended centuries back that it should be brought to 1 to 50, we are still at 1 to 21, from 1 to 20. And therefore, we must all look at this issue from a pragmatic point of view. We must all sit together. Justice Oak referred to the Manan Kumar Mishra, the Prashant Kumar, but he forgot that we also have the President-elect of Law Asia. We also have the members of Bar Council of India and the Bar Councils of Maharashtra and Goa. I'm sure that if everybody has a will, if everybody works together, the day will not be far that we can find out some solution to at least reduce such a pendency to a substantial extent. I'm sure that Justice Chavan would contribute to that. I take this opportunity. I would not like to speak in details about the book. The earlier speakers have already told us the importance of the suggestions given by Dr. Warunjikar. As said by my brother, the leaders of the bar will take it to the appropriate authority. The legislation, the legislative amendments have to be effected by the parliament. And these are social welfare legislations. We have directive principles, and to fulfill the promise given by the constitution makers in the directive principles, various such enactments have been enacted with a novel object. Maybe many of them have not achieved the desired purpose, but it cannot be denied that they have played their role in fulfilling the object for which they were enacted. Insofar as P.N.D.T is concerned, we cannot deny that the ratio of female infanticide has reduced. The discrimination which a child had to face in the womb, to some extent, has been taken care of by the Act. Every law has a positive as well as legal, as well as negative effects. There are innovative lawyers who are always trying to find out loopholes in the Act and use it to the disadvantage. We have seen many litigations in the Bombay High Court. Both my brother Justice Oak as well as I must have handled at least hundreds of matters concerning P.N.D.T. And therefore, this work of Dr. Warunjikar, I'm sure, will not only pave the way for removing the evils from the society, as rightly pointed out by Shri Abhay, that the message has to be taken to the far-off areas, to Melghat, to Gadchiroli, to remote areas of Rajasthan, to remote areas in Himalayas, where the people should know what are their rights. They should know what is the Act and what is the benefit of that Act. And only thereafter, the purpose of the enactment, the purpose of the social welfare legislation would be fulfilled. I once again congratulate Dr. UDAY Prakash Warunjikar, his learned wife, the members of his family who stood behind him and supported his endeavor. As pointed out by earlier speakers, he will come with such more works which are important for the society, for the nation. I conclude thanking him for giving me an opportunity to be with you this evening. Thank you very much.
Thank you so much, sir. Now, there is one important announcement. I request Advocate Jen Bhave to make that announcement.
I am standing on behalf of Chairman Bar Council of India, Advocate Manan Kumar Mishra ji, and all my colleagues, members of the Bar Council of India. It was a very, very nice function organized by Warunjikar family. And as a gesture of sharing the pride and privilege which Advocate Dr. Warunjikar has given to the legal fraternity of making a legal research and having a thesis on a very difficult subject of this sex determination, it has been decided by Honourable Chairman that the entire expenses of this function, right from Mumbai to Delhi, will be borne by the Bar Council of India in respect of Dr. Warunjikar. Thank you very much.
Thank you so much. I'm sure that all the entire family, all of us are overwhelmed with this announcement. Now I request Advocate Gargi Warunjikar to kindly give a vote of thanks. Gargi Warunjikar.
Honourable Shri Justice Bhushan Gavai, Honourable Shri Justice Abhay Oak, Honourable Shri Justice R.C. Chavan sir, senior advocates on the dais and off the dais, namaskar and good evening to all. It is my great honor and privilege to propose the vote of thanks for today's such wonderful evening. On behalf of Bar Council of Maharashtra and Goa and Warunjikar Institute of Rule of Law, I should admit that the entire law fraternity today has come over here, and I would love to propose a vote of thanks to each and everyone present for this august gathering. I would like to express my deepest gratitude towards Honourable Justice Gavai for gracing this auspicious occasion. He has explained us not only the importance of rule of law, but also how to achieve the purpose of the law or the objective behind the laws. A big thank you to Honourable Justice Abhay Oak for his efforts towards writing the foreword to the book, and also his sharing his insights on the social legislations and how do they function, or what is the importance of such social legislations. A big thank you to Honorable Justice Arshit Chavan, who has explained us how to use the strength of the bar for the rule of law, or how to implement the rule of law. I must mention our deep sense of appreciation towards Professor Dilip Uke sir, without whom we wouldn't have seen today's event itself. Further, I would like to say thank you to a lot of the senior advocates who have gathered over here. Advocate Vasantrao Sarunke sir, Advocate Jayant Bhave sir, Senior Advocate Sham Diwan sir, Prashant Kumar sir, Manan Kumar Mishra sir, and all the dignitaries on the dais. I would also specially would like to mention all the members of Bar Council of India who have been present over here. Advocate Apurva Sharma sir, the Chairman of Executive Committee, Advocate S. Prabhakaran sir, the Vice Chairman, Advocate UDAY Prakash Sharma sir, the member. All the members of Bar Council of Maharashtra and Goa who have come all the way from all their hometowns to over here. Advocate Amol Sawant sir, Advocate Milind Thobde sir, Advocate Gharge sir, Desai sir, Chavan sir, Parijat Pandey sir, Govardeep sir, and Satish Deshmukh sir. Apart from the members of the Bar Council of Maharashtra and Goa, we also have a few staff members who have come over here to help in organizing this event. That is Denge sir and Patel sir. Honorable Justice Naidu sir is also with us. A big thank you to you, sir. Advocate Anandita Pujari ma'am, Advocate Mishra sir, Advocate Sharma sir from Bar Association of India, Advocate Rachana Srivastava madam, the Chairman of Women's Lawyer Forum, Imfat madam from who is the consultant at Government of India for P.N.D.T. Mr. Rizwan sir, who is from an organization known as Girls Count, Advocate Varsha Deshpande madam, Advocate Chaitra and Vanraj Pawar, Advocate Sadhana Mahashabdi madam, and also the research assistants who have helped in researching or making this whole PhD and the whole book function today. I would also like to thank the printing partners, that is Eastern Book Companies, Mr. Kumar sir, who is a very close friend of my father. Also the media partners, that is the LawBeat, who have come over here on very short notice and who have promised to broadcast it live. Apart from this, there are also a few distinguished dignitaries in the audience. Shri Borikar from Adhivakta Parishad, Advocate Rekha Agarwal madam, the Chairman of National Commission of Bar Association, Advocate Bhagwan Rao Salunke, Advocate Kishore Lambert, Advocate Rahul Chitnis, and Sachin Patil from who are the standing councils of Government of Maharashtra, Advocate Triveni Potekar madam, Advocate Sonali Patil madam, who is the Office of Registrars at the Supreme Court. Last but not the least, all the anchors and whom we generally called the Parda Maagse Kalakar, without whom this whole function would not have been there. Lastly, the audience who have patiently listening to such a huge program and who have gathered for inauguration or the publication of a book on a very law which has a super speciality. I would also like to apologize if by mistake or inadvertently I have missed anybody's name, but I would like to thank each and everyone for being present for this August gathering. Thank you very much.
Thank you so much, Gargi. Before I declare that today's program is concluded, there are a couple of announcements. There is a dinner after this program, so kindly join us for the dinner. And the book which is published today is available at a discounted price of ₹500. And lastly, I request all the volunteers of today's function to kindly come to the stage so we can freeze this moment forever. Thank you so much. The program is concluded.